Uh, I seem to have been left with the enviable task of being the last speaker of this year's seminar. It's like in the movies, nobody wants to attend the last day, last show of screening. It's always when attendance is the least and interest has waned out. But such is my task. I got to make my last day, last show, legal show a blockbuster. Hopefully I have your attention for that. Well, 30 minutes and you're all free. Today I'm talking about legal issues being faced by marine surveyors in India. Most of these topics in today's seminar has come out from my discussions with Tony, Milind, Captain Anand, Uday Murthy when I met him in Dubai. And over the years, these issues keep cropping up, and I thought it's good to sort of deal with them individually, so it might be helpful to all of you. And some of these issues might be more pertinent to when dealing with insurers, survey reports vis-a-vis insurers, as opposed to, let us say, when you're submitting a report to a P&I club or for a foreign party. Yes, there we go. Some water, please. Just had a sweet, some kind of... The first thing is the presentation will address the following issues. Admissibility of survey reports issued on without prejudice basis as evidence in a court of law. In fact, that was the first question when I asked Milind, what is something that interests you from a legal aspect? Told me, Kaushik, we put in so many disclaimers in our reports. Some is regarding liability, and we keep putting without prejudice everywhere. I have seen surveyors sometimes put it on the top of the letterhead, without prejudice. Sometimes they put it in discreetly at the end of the report, without prejudice, or sometimes they have a disclaimer in the report, it's put in that, without prejudice. And what do we mean by without prejudice? And does it affect the admissibility of a survey report before a court of law when you tag it with a without prejudice basis? There's a case that's been decided a few years back, so I'm just dealing with it, the latest update as such. Second is conflict of interest for marine surveyors. I'm just going to skip through this part because I think enough speakers have spoken about it. So I'm just going to get away from my slide for a bit, slip the sides and go to the relevant ones. Third one, marine surveyor as a witness and an expert witness before a court of law under the Indian Evidence Act. There is a difference being a witness and an expert witness as far as the Indian courts are concerned. And how does it affect marine surveyors in the event they are called before the court? The fourth, opinion of surveyors on admissibility of claims as per the IRDA regulations. This issue has been spoken in great depth by Brother Tony Fernandez over the years, and very emotively as well. And the aspect of being a witness and the next issue of the opinion of the surveyor are kind of interlinked, so I'll be dealing with them together at times. And things to keep in mind while issuing a report. I'm not going to comment upon how a report is to be issued. It's just things to keep in mind in case the report is brought into question before a court of law. Very simple things which surveyors tend to forget and which is very, how do I put it, detrimental to their client's case. When they meet the lawyers, they understand that these simple mistakes have been committed and it's difficult to go back on them. I'm going to highlight on those 2-3 simple issues. It's more of issues for companies having a large pool of surveyors working with them. Okay? So the first is on the aspect of without prejudice. What do you mean by without prejudice? It's without loss of any rights, in a way that does not harm or cancel the legal rights or privileges of a party. There are many definitions, but this was the simplest one I could just pull out. Traditionally, parties tag a document without prejudice in order to make it very clear that there is a privileged communication. Giving you a simple example, there might be a dispute between two parties, A and B. They might want to enter into a compromise. But how do you freely communicate to each other? When you know you have a court matter going in there, on one hand you want to compromise, You want your terms of offer to be very clear, but yet protect yourself from making any admissions that might be detrimental to your interest. So you tag them as without prejudice basis offers are being made. Should negotiations fail, settlement not be arrived, in which case nobody can take these documents before a court of law and say, look, he admitted to me in this letter, because the court will not look into it because it's been tagged as without prejudice. That means these offers have been made notwithstanding the rights contemplated by the parties in their underlying contract. That's the basis on which the concept of without prejudice sort of developed. Then people started using in their documents. And I spoke to a number of surveyors, some non-IIMS members, some IIMS members. I received a mixed feedback as to why they put it. Some put it because everybody puts it. That's one reason. Some people say I'm limiting my liability in case I do any mistakes. I always say it is without prejudice to the parties' rights. Some say I'm making an opinion on the facts. Some say I'm giving an opinion on the claim. I want it to be clear to the parties it is without prejudice to their rights and not affecting their rights. It is a contradiction in itself. You make an opinion saying X is wrong, Y is wrong, and then you can be saying without prejudice. So that's sort of a contradiction over that. Anyways, so I came across only one case that's dealt with this issue as far as survey reports are concerned, dealing with Indian insurers. A consignment of 1,080 tins and 77 cartons were dispatched from Mysore to Bangalore. Consignment was badly damaged during transit. Insurance company appointed a surveyor to assess the damage caused to the consignment. Survey issued a without prejudice report quantifying the damage or loss, as most surveyors do. Based on the damages quantified on the survey report, the insurer settled the claim. Subrogation took place. He pursued the transporter. The transporter was in possession of the survey report because it would have been a joint survey, or he didn't appoint a surveyor, so nonetheless he must have been aware of the report. Now, when the insurer proceeded against the transporter before the court of law, there is a case that is Born Food Products versus Planters Airways Limited. The transporter challenged the admissibility of the survey report on the following premise. He said the survey report itself was without prejudice, and therefore the same could not be relied as a relevant piece of evidence in view of Section 23 of the Evidence Act. Section 23 in simple terms incorporates the doctrine of privilege. That is, if there are any communications exchanged where the parties agreed to keep it outside the purview of the courts, then the courts will not look into those documents. And one way parties keep those documents outside the purview of the court is to tag those documents as without prejudice. Like I said, when you have a dispute, you exchange offers back and forth per prejudice basis, so you can't bring them into the purview of the court. In this case, the surveyors issued the report on a without prejudice basis. The transporter challenged, you can't bring this in. He said it without prejudice, so I don't want this document brought in because it is detrimental to his interest, bringing in the survey report. So the division bench, the matter went up to the division bench, from the single bench and to the division bench of the Madras High Court on the admissibility of the survey report. And the court held as follows. In our considered opinion, the recommendation of the surveyor that his assessment with respect to the quantum of damages is without prejudice would only mean that the same is subject to negotiation between the plaintiff, that is the insured, and the second plaintiff, the insurance company. Therefore, neither the opinion of the surveyor, that is assessment with respect to the quantification of damages without prejudice, nor the acceptance of a lesser amount by the plaintiff than recommended by the surveyor would be a ground to reject the document. So what the court has effectively said is, when you caveat, at least as far as Indian law is concerned, a survey report saying without prejudice, all that you're saying is the parties are free to negotiate and decide how they want to settle this dispute. But as far as your opinion that you're giving is concerned, that is a prejudiced opinion. That you're saying X is wrong or Y is wrong, or X is bound to pay Y or Y is bound to pay Z. or under the policy the X is supposed to pay Y. That conclusion of that surveyor cannot be deemed to be without prejudice communication. All he is saying is, let the parties decide how they want to settle it. But as far as my conclusion, my facts of the report, whether it favors X or Y, or it is a balance, that is my view which may prejudice and I am not responsible for it. That's what the court has said. So they took this document into the case and they passed an order. So this kind of starts with thinking, what is the purpose behind a survey to put it for prejudice? Is your intention to limit your liability? Is that your intention? Because some people have said that to me. Is your intention to cover yourself in case the report goes wrong? If that is the case, it is not going to help you. And the second reason, which the court did not go into, which it should have gone into, regarding the issue of the without prejudice clause. You see, all insurance claims, as you're all aware, under the Insurance Act, if your claim is beyond 20,000 rupees, the insurance company has to appoint a surveyor. That is a statutory duty of the insurance company, right? Pursuant to the statutory duty, the insurance company exercises its powers and appoints a surveyor, right? So your report is flowing from a statutory power under the Insurance Act. When you are obligated to provide and prepare a report in the Insurance Act for benefit of the insured or the assured, just by putting a without prejudice remark on it does not give it a power of privilege such that it can be kept away from courts. If that is the case, then no survey report would be brought into the arena of the court. And the very purpose of the Insurance Act for requiring insurance companies to appoint surveyors would be lost. So there are two aspects to it. One is the statutory aspect which the court didn't go into, which I think is relevant. So things to think about. In case you are qualifying without prejudice, what is the intention of doing it is something surveyors need to think about, and how it is affecting them and their clients. Okay? This is just one case. The jurisprudence is not fully developed as far as India is concerned. For the case vis-a-vis the insurance company appointing a surveyor, there may be cases where a surveyor is given an ad hoc assignment on a private and confidential basis, which is strictly supposed to be kept away from the purview of the courts. There may be an exception in those cases, but one will have to look into it more carefully of surveyors. If you are putting this, what is your intention and what do you seek to achieve out of it? Okay? Conflict of interest, I'm skipping this. I hope that's okay.
Yeah.
Brother Tony?
Yeah.
Wherever we can take. Now, like I said, we dealt with the issue of without prejudice. Surveyors give out opinions on facts, and the Indian regulations are also required to comment on the maintainability of the claim under the insurance policy. Sometimes venturing into my area of specialization, sometimes perturbs me a bit, but nonetheless, we deal with these things. So, in this slide, we want to talk about a surveyor who is involved in a case as a witness and an expert witness. It is very important to understand this distinction, because many of you issue survey reports which insurance company rely upon, which the assured doesn't agree, he takes you to court. You are called before the court. In what capacity do you appear before the court then? And sometimes you are called as an expert witness. So you should know in what capacity you are going before the court. To give you a simple example, you have a claim under insurance policy, or a marine hull claim, or whatever you want to say. A survey report is issued, say for P&I, for hull and machinery, for cargo interest. You issue these reports. And then comes the point of an expert witness. Now a surveyor can be an expert witness only under the orders of the court. Okay? On an application of the party, or the court can suo motu call him and say, boss, I need your advice on this. I'm a little bit out of my depth, so could you come and give me your comments? Now, as regards to the first section, where a surveyor issues a report for a PNI, H&M, cargo, insurance company, quite naturally the report is distributed amongst the parties. They decide whether to pay a claim or not, or reject it. If it goes to court, all the reports are disclosed before the court. This is the view of my surveyor. Based on the facts, based on the claims and the policy that was in the policy is maintainable, claim is maintainable, so it has to be paid. Quite naturally, the defendant disagrees with the surveyor. And on most occasions, I'm not standing on prejudice, but the surveyor generally issue a report that may be favorable to their principles. So, surveyor in those situations, first case, that is in this case, when he's called in as a witness, either by the plaintiff or by the defendant. He's called before the court, he's put in a witness box, the statements contained in his report are questioned, he's cross-examined, he's given the required to provide an affidavit of evidence, and in this case, we are appearing as a witness for one of the parties. Let's assume in this case the court is frustrated with each surveyor is giving an opinion favoring his principles. It quite happens. The court said, listen, I don't trust anybody, I want an independent witness. In which case, the court suo motu appoints a third party to come and assist the court. You are not assisting the party to the dispute, you are assisting the court to the dispute. Or there may be a case where one of the parties suggests that given the complications of the case, it may be helpful to have an expert witness. Given that we have so many differing views of the survey of the witnesses, it may be helpful to have an expert witness. So a party applies to the court, seeks the permission of the court. Can I apply an expert witness? Can I bring forward one? The court grants him permission. You bring along an expert witness. Now this is the overall structure where you as surveyors get involved in legal proceedings in India. Now we've understood the basic framework. So you're sitting in your office and a lawyer comes to you. Would you like to be an expert witness in my case? You're actually very excited. Your legal opinion, you feel valued, that your intellect that you have garnered over the past 30 years is being valued, and you're going to advise the judge, your name is going to be recommended. They're all very exciting things. But before you say yes to such a request, that I will agree to be an expert witness, you may propose my name as an expert witness, you need to consider these 5 basic points. Or rather, I would say 5 to 6 checks that you must do before you even think of proposing your name or agreeing for the lawyer to propose your name. First, have you previously advised either of the parties in the subject matter under dispute before the courts? This is a very basic requirement. Because if the other side is aware that you have advised on the subject matter in dispute to one of the parties, they will be aware, maybe you might have given a favorable opinion for the party that asked you, and they will say, he is a biased expert, he may be an expert in his chosen field, but I have this document where he has already expressed a view on a particular subject matter, so I know what his answer is going to be. So I don't think he qualifies as an expert witness before this court, though he may be an expert in this particular field. Number 2. Do you have any expertise on the subject matter on which your expert opinion is being sought? And this is where a lot of lawyers make mistakes, because most of us are not seamen. We don't know the difference between chief engineer, master mariner, captain, what are their respective roles. I have learned it from all of you because I have the advantage of interacting with you. But most of my colleagues in the profession may not be knowing. So sometimes you have to be doubly cautious. If you have a case where a lawyer comes to you and saying, you have been a master of a vessel, but you have been a master of a bulk carrier, but the dispute is in relation to a vessel which is a liquid carrier. carrying oil cargoes. If I was the opposing lawyer, I would discredit you. I would say he has no experience in dealing with a product tanker. He's been a bulk carrier master. So your witness you would be thrown out. Whatever the opinion you had given would not be considered valid. So sometimes you ought to be a bit more smarter when the lawyer comes and asks you. You've got to think a bit more on these points. Do you have the required qualifications, knowledge, work experience on the subject matter to appear before the court as an expert witness? Because you have to remember, when somebody is proposing your name, the opponent lawyer will be under the impression that this expert is going to give an opinion favorable to his client. More than your lawyer coming, you should be doubly sure and be aware that you satisfy all these criteria. It is better you do the homework than expecting the lawyer to come and do it for you. Because like I said, we are not seaworthy, most of us lawyers. And the fourth one, provide a copy of your profile to your lawyer who has asked you to depose as an expert witness before agreeing to depose as an expert witness. It is very important. Because he goes back to his office, he reads your profile, he thinks about his case. Though for you, you may feel you're relevant, but once he compares your profile with a case in dispute, he may get back and say, listen, I think I'm going to think twice about proposing your name and thank you for proposing. Rather than you have somebody in the opponent coming, picking holes on your profile and CV and you being embarrassed in court. So, it's very important. The most important thing is, do you want to be an expert witness? Wanting to do the job is more important because it's a very challenging job. Your profile, your CV, your qualifications, every single aspect of your achievements will be scrutinized. Do you want to put yourself up over there? If you feel it up to the task, only then you should do it. Don't do it for an experience. It looks nice that I've come as an expert witness. Because last thing you want to do is be called as an expert and be said, please go back. You don't fit the criteria. It will be a nice reported judgment for the lawyer of the opposing party. He will brandish it over all the conferences. So, basic things to think about. And in fact, this criteria, when I was just talking about this, is when surveying companies depute an attending surveyor for a job, they should always see if the attending surveyor has the required qualification, experience and knowledge to conduct that survey on the vessel. Because you see, the attending surveyor is the one who is going to be called into the witness box. Because nobody cares about the company letterhead. Everybody cares about the person who has visited the site for inspection. So you should always, before sending somebody for a job, do you think, will this guy test a scrutiny before a court if it is a high value dispute, high value claim? There's no point sending you most junior, most surveyor, and then when he's called before the court 5 years down the lane, he's asked a question. At the time of your survey report, when you conducted the survey, did you have the relevant experience? Were you qualified to do this survey? All these small things come up only when you go to court. Keep the little things in mind. Not that every case is going to be a doomsday case, but if you have these things in mind, you know you're prepared for the worst. So those are the few things to keep, even when you're not being called as an expert witness, when you're sending your attending surveyors to do jobs. Issues to be kept in mind after agreeing to be an expert witness. Now you want to do the job, you're excited, you have gone through all your checklists, you say, now throw me before the judge, now I want to be an expert witness. But then you got to ask yourself, you're an expert witness for whom? Are you an expert witness for the party or an expert witness for the court? In India, you are an expert witness only for the court. Unless English proceedings or parties keep on submitting expert evidence and expert witnesses, normally the court prefers to have one expert witness which assists the court. And ask your lawyer when he intends to apply to the court to obtain the permission of the court to utilize you as an expert witness. Because he will come and meet you on one day, and then he might come 6 months later and say, I got the court order, you please come and depose on this day and justify your affidavit and opinion. You may be on a survey, you may be out of station on a holiday. So the small things of scheduling is very important. Because lawyers tend to forget sometimes. And since things move slowly in India, these things take much more longer to sort out. Once the permission of the court is obtained, you must remember that your duty is to assist the court and not the object of the party which has suggested your name as an expert witness. It's very important. When you come as a regular witness, sometimes surveyors may give biased opinions. You come with a predetermined notion that you are supposed to say things that is going to be beneficial for your party. I'm not supposed to say this, but before you go to court as a witness, the lawyer will call you into his office. He will give you a 2-day session of training on how to withstand a cross-examination, and he will prep you up for it. There is a certain expectation when you appear as a witness for a particular party, so you are expected to say certain things. But an expert witness, you only have to assist the court. You have to be as brutal and as impartial as possible. Now let's remember the following. An expert is not a witness of fact. What do you mean by this? When you are an attending surveyor and you issue a report, you come in as a witness, you have seen the incident. You have seen the plating, you have seen the collision incident, you have seen what is the indent in the shell plating, and you are able to depose to those facts. As an expert witness, what happens is, the court decides this, he is going to be the expert. The court will frame the issue for you. It will set out the facts. This is the fact of the case. This is the issue on which the court wants assistance. You please answer this question for me and tell me in your expert opinion what you think of this. So the case is clearly set out. You are just giving an opinion to the court, as opposed to a witness, a surveyor who's been there. He's a witness of fact. He has seen the shell plating, he has seen the collision, the cargo contamination, the cargo holes, so on and so forth. Okay? So, an expert is not a witness of fact. His evidence is really advisory in character. The duty of expert witness is to furnish the judge with necessary scientific criteria for testing the accuracy of the conclusions, so as to enable the judge to form his independent judgment by application of this criteria to the facts proved by the evidence of the case. So in essence, what the court only wants is your opinion. It doesn't want your version of the facts. It sets the question for you, you answer the question, and that's it. Once that is done, your opinion is subject to scrutiny by the judge and by the adversarial advocates. And you can, if you want to, it has happened in some cases, where the surveyor has revised his opinion. Sorry, the expert witness has revised his opinion. That is allowed. Because at the end of the day, the judge wants the correct opinion. He is not bothered about technicality, whether you get it right in the first time or the second, but preferably you get it right in the first time, it saves your embarrassment. Okay? So this was a case in the case of state of Himachal Pradesh versus the state of Bihar. And this principle applies whether you come as an expert witness, as a surveyor, as a fingerprint handwriting analyst, or as a forensic expert. The same principle applies. Okay? Then, opinion on the claim as per the IRDA regulations. Now, Brother Tony Fernandez has been very vocal about this for a number of years. I have seen him wax eloquent in so many seminars on this topic, I don't need to repeat it. In fact, in the last seminar, we had presented 4 cases on this topic. And all of us know surveyors appointed by insurance companies. They keep giving opinions on the claims. The insurance companies use that opinion to repudiate a claim. At the end of the day, if you look at the trend in the past 3-4 years of jurisprudence regarding insurance claims and surveyors, as an objective person and compassionate person, one would say that the surveying community is not looked in a good light. It looked as a hired gun. It is not me saying it. You read the judgments. Brother Tony will be aware of it. At the end of the day, you're all surveyors. Marine is a prefix, am I correct? That's added to the word surveyor. So whether somebody in a fire claim gives a bad opinion, or whether somebody in a motor policy claim gives a bad opinion, it affects your industry, it affects your profession. Because a judgment in a fire policy will equally be applicable in a marine policy as regards, it sets a precedent that when a surveyor gives a bad opinion, it should not be relied by the court. It is discarded. And those judgments tend to populate other fields of surveying as well. I know this can't be done, what I'm suggesting, but I think it is about time surveyors put a firm foot when insurance companies request surveyors to give opinions on the maintainability of the claim. It's not possible for all of us, but I think the trend should start. Convey to the insurer that an opinion on the claim is purely a legal issue and will be outside the ambit of the surveyor's specialization. This may be in contravention to IRDA regulation, but the IRDA regulation does not say if you don't issue an opinion on the claim, a survey report is bad. If the insurer persists, be prepared for the report and the opinion on the claim to be scrutinized before a court of law. And many have happened, and not many opinions given by surveyors on the maintainability of the claim has been upheld. All of them have been discarded. When in doubt on the maintainability of the claim, you are still being pressurized by the insurance company. Put your foot down. Do not provide an opinion. It may be good for the future business, but the last thing you want is to have a reportable judgment against your name 5 years down the line, and that being a topic of conversation in all seminars. You don't want that, and it is not good. A bad opinion on claim will always find its way before a court of law, where it will be scrutinized and discarded. I'm not blaming surveyors to give opinions on claims. That sometimes it's a legal issue. Your opinion on facts is perfectly valid. You are the expert. You have trained in that particular field, be it marine, be it hull, be it motor insurance. You can discern it. You are the boss. From this, I thought about this for a long time, and I felt two contradictions are being faced by the surveyor here, an Indian surveyor. A good report on facts will forever be forgotten if the opinion on the claim is incorrect, and the insurer uses the surveyor's opinion to repudiate the claim. Till date, in the recent jurisprudence, if you read the judgments, it will always flow. Insurer's appointed surveyor says claim not maintainable. Upon receipt of survey report, the insurance company repudiates the claim based on the opinion given by the surveyor. So the insurance company does not want to decide this issue by itself and apply its mind, whoever the legal officer that is. He is using you as a tool, as a means to an end to reject the claim. And the opinion of the claim in the survey report is just 3 to 4 lines. But that destroys the sanctity of that report. You might have an excellent report on facts, wonderfully narrated, but if you slip up on the opinion on the legal front, the whole thing is lost. So, do you want to be used as a puppet by the insurers, or do you want to create a body of professionals whose integrity will be beyond reproach? And I think that's the crux of the issue. Year after year, when we met since 2012, 2010 and 2014, and this is where IIMS wants to do that. So I think more firmer steps need to be taken in this regard. And this is my conclusion on this particular topic of survey reports, because I've been interacting with all of you for the past 4 years. Tony, Captain Anand, Milind, Uday, Badvez, all of you, even from Goa, Felipe, Palacio, and Tina in Singapore. And it's sort of, I speak more with surveyors on shipping disputes than I speak with lawyers. And I feel I have a close connection. And when I read this, when I thought about this, what does a survey report mean? What is a survey report? Leaving aside the issues of facts and what does it mean for a surveyor, I tried to place myself in the feet of a surveyor and felt what it might mean for him, and if I were a surveyor, what it might mean for me. When I came up with this tagline, every survey report that is issued is your legacy to the industry. Please make sure the legacy is a good one. Because your report goes to P&I, H&M, cargo, it comes into my hands, lawyers' hands. It finds its way in a court of law. And everything you do is a legacy you leave for yourself. And we have met today, we have each sort of left legacies of each other in our meetings. And I met him, this is my legacy. Legacy doesn't have to be a bequeathing of property. It's an impression you create. Because that's all we'll be remembered by. And the past trend is, it's not been a good legacy for Indian surveyors. And this needs to change. And I'm not saying as a lawyer we are beyond reproach. We ourselves do a lot of mistakes. But even for us lawyers, we love the fact when we get a good case being reported in law reports. It gives us a tremendous high that we got it right, the judge was on our side, and it gives you an amazing feeling. You see those words in the law reports, XYZ instructed by Kaushik, and you know that that judgment is going to be there for a long time, and people will rely upon it and they will see your name. That's my legacy to my profession. And I remember 5 years back, we had a major case in Goa. It was a reportable judgment, one of its kind. And 6 months ago, somebody called me on the case. Hey, listen, I saw your name on this case, you worked on it, a fellow lawyer. Could you let me know what it is in your case? We've got a similar case coming up. It feels good. And as the marine industry grows in this country, you're going to have more litigations on survey reports. And your reports are going to be published in court judgments when lawyers like me will either try to fight with you or support you. It is very important the court says XYZ surveyor has given a commendable report. I have no reasons to doubt his integrity. Claim payable, claim not payable, that's a separate issue. But that's the kind of reporting you should see in the jurisprudence in India. Now this third point, which I forgot to highlight in this, I'll give you an example of what happens when you in your survey report issue an opinion on the claim, which is a purely legal issue. You have someone to quote as a witness, correct? Your report is basically split into two halves. One is the opinion on the facts, second is the opinion on the maintainability of the claim, which is a purely legal issue, right? You brought into the witness box. Let's say I am opposing you guys. The first question I would ask is, Mr. So-and-so, 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 could you please let me know what is your experience and what is your education qualification? You will come back saying, I have 25 years of experience in the life of seaman, 15 years on board vessel so and so, joined as a cadet so and so, 5 years I worked with a ship management company, and 5 years I have been a surveyor. Excellent. Second question I would ask you is, do you have any legal qualifications? You would say no. The third question I would ask you is, given your qualifications, do you think you're qualified to advise on a legal issue? That's a contradiction you're all facing now. At least the surveyors are working in India. It's a very dangerous path you're treading into. Because the insurance company is just quoting your opinion to liquidate a claim, they are not forming their own opinion. So you are at the forefront of the insurance company. And with the three questions I've asked you, I don't think the opinion that you have given holds any credence. What did I say? To be a witness or expert witness, you need to have knowledge, you need to have qualifications, you need to have experience. Just 25 years in the sea without a legal qualification, does it give you the authority to advise on the maintainability of a purely legal point? I don't doubt there are a lot of you, many of you, qualified to advise on claims. You are, I've learned a lot. But the stumbling block each of you will face is this: if a surveyor is ever scrutinized in cross-examination, your answer will be so evident that you do not have neither the experience nor the qualification to advise on this point of law. So you are at the forefront, and I think it is time that you guys take the cudgel and do what is most appropriate for your profession. This is what I think that the Indian branch of IIMS can do. Coordinate other members of surveyors fraternity, lobby with the IRD and insurers to discuss the practice of asking the attending surveyors to advise on the claim. I think Captain has started this thing in 2005, we're in 2014 now. We're, how do I say, tidy bunch of people, so to speak, who have gotten together. And we need to sort of lobby for this. India is a place of lobbying. You have to lobby if you want something. Anna Hazare fasted for 15 days, he still didn't get the bloody Lokpal bill. If you want this change, you'll have to do something more. For example, the seminar, we spent I think 6 months coordinating on the seminar, Milind and everybody, London, Dubai, and we need that same coordination on this aspect, and we are here to help, I'm here to help, I'm always there. So we need to make some steps, take some steps, only then we will know. Write to the insurer to discourage this practice. This might be detrimental to some of you, not in the sense, I'm not talking about people sitting here, but to some people in the industry. But sometimes only in the face of opposition do you have success. Try to work on a time-bound schedule to achieve this objective. May not be 1 or 2 years, but at least let's get some traction on this. In conclusion, the call for change does not come from the industry. The regulatory authority will neither listen nor react. You need to start having the right people listening to what all of you have been saying for the past 5-6 years. I don't know how it is done, but I think we should start doing something about this. Now, issuing a report. I'm not going to talk about how you should issue a report, you're already aware. I'm talking about certain legal things which, when we lawyers face, like I said, while issuing a report, keep in mind that it may land up in a litigation. That's the most important thing you have to keep in mind if you feel that the claim is the type that might be fought upon. And these things generally come up at the time of a trial stage when you have to lead evidence. Because when you file the proceedings, everybody looks at the documents. The merits of a case is decided when you go to trial.
Somebody else signed it.
When you bring in your witnesses,
You see,
when
he's
you
a
read
witness
evidence
of
in the
fact.
documents,
But
after
he
the
has not been to the
authenticity and the
incident.
correctness of the information contained in the documents, as to who has given all this information in the documents, that is where the nitty-gritty of the case is fought out. So now you understand the importance of the witness, expert witness, the qualifications, the knowledge, the experience. All these things will come out in trial. And while issuing the report, this is a very small thing, but it can be forgotten, especially for big surveying companies. Make sure the attending surveyor signs and verifies it. Don't let anybody sign it.
If at all you feel
We had a case once where we had a favorable report, a good report. When we went to a recording of evidence, we came to know the guy who signed the damn report didn't go for the inspection. Somebody else signed it. You see, he is a witness of fact, but he has not been to the incident. How do I lead evidence to the person who has not seen the incident? I can't put the CEO of the company who signed the report on the box because he was not there at that point in time at the place of the incident. It's a very basic mistake which may be computed, I am not aware. But that should be rectified or nipped in the bud. In case any surveyor leaves the organization, please keep the contact details of the attending surveyor and be aware of his whereabouts. If at all you feel a case has gone to litigation, you feel this man has given a report, please keep track of him. Especially in India, it takes time for the matter to come to trial. Maybe 3 years, 4 years, 5 years. 5 years down the lane, you're in the lawyer's office, and then you want to find A, B, C, yaar, kidhar gaya wo aadmi? You call Sanju, Manju, Anju, everybody, find out his contact details, I need to find him. And then you know he's in Dubai or he's working in some other plush company. And then you say, Sanju, remember 96 you were there with me on the report, on the case, the ship you went. Yes, boss, I don't remember. You better get your ass back to Bombay now. You're giving evidence. So these things happen. Because surveying business is a flourishing profession. People are traveling around the world. They want better opportunities like all of us. So if you have a strong presence in your country, keep track of the guys who have signed your reports, especially the ones that you think are going to litigation. That is very important. Like I said, it is the attending surveyor who will be called to the witness box to depose on the survey report. You may be the best surveying house in the world, but it is who you send on the field that matters the most, because he is the one who is dragged into the witness box. It is the attending surveyor who will be cross-examined, and not the company on whose letterhead the report was issued on.